very important, but probably not sufficient. Moving on to issue number 8, dealing with the death penalty. Again, I would like to thank for the detailed information in the report, the answers provided to our list of issues. We welcome the fact that more and more states abolish the death penalty. We welcome the fact that the number of executions is declining in most states that retain it. The study authorized by Attorney General Eric Holder addressing the overrepresentation of African Americans in the death row population, this study is most welcome. It highlights concerns shared by this committee too. Discrimination is bad, but it's utterly unacceptable when it leads to death. Just some days ago, Glenn Ford, an Afro-American wrongly convicted by an all-white jury more than a quarter of a century ago, was exonerated on the basis of newly discovered evidence. He's already the 144th case of exoneration of a person wrongly sentenced to death since 1973, I'm informed. 144 cases of wrongfully convicted persons convicted to death is a staggering number. It points, at least to me, to fundamental flaws in the judicial system administering the death penalty. As the report I just mentioned, I'm also concerned about the administration of untested legal drugs. I understand that in January of this year it took Dennis McGuire 15 to 20 minutes to die, an execution that may have amounted to cruel and inhuman treatment. I also understand that the state of Mississippi plans to execute 2 individuals later this month as we meet here, despite the fact that up to now it has not shown that the pentobarbital that will be used has been acquired from legal sources, has not yet expired, has still the full effect on the person to which it will be administered. Mr. Chair, please allow me to ask in this context the following questions. First, what is the federal government planning to do to effectively ensure that the death penalty is not imposed as a result of racial bias? The Access to Justice initiative is certainly an important step, but does the distinguished delegation think it's sufficient to address the identified far-reaching problems? To what extent does this initiative solve also the problem of legal representation for litigants in death penalty-related civil cases? Second, does the distinguished delegation share the opinion that the fact that 16 retentionist states do not provide for compensation for the wrongfully convicted, and that some other states just provide for symbolic compensation, that this fact is incompatible with the right to effective remedies under the Covenant? Third, what is the federal government planning to stop the use of drugs for executions that are not approved by the US Food and Drug Administration? And fourth, why does the state of Mississippi not release information about where they got the drugs envisaged to be used in the 2 planned executions? Does not inform about what kind of drugs they are, when they expire, and how they will be prepared for use in these 2 executions? Why is the state of Mississippi in this way depriving the 2 individuals concerned from using available remedies effectively? In the absence of such information, these 2 persons are obviously unable to substantiate their claim that the drugs envisaged for use would lead to suffering amounting to cruel and inhuman treatment. Is the state of Mississippi confident that, in light of the fact that many capital defendants have received deficient trial, appellate, post-conviction representation, is not going to execute another innocent person? I'm not claiming that they are innocent. I'm just wondering, in light of the large number of exonerations, whether we can be sure that they are. Finally, and I will end with this, I turn to issue number 9 on gun violence.
Again, my name's Jim Hood. I'm Attorney General of the state of Mississippi, and as you can tell, I'm from the South part of the United States, and I have a slower speaking accent. So hopefully the interpreters will be able to, I'll be slow enough. But I've got 5 minutes to go through about 8 topics. So I'm going to have to try to speed through them as quickly as possible. A couple of things I'll add. Mr. Rodriguez-Recia asked about domestic violence and what are we doing in the prevention area. In the state of Mississippi, through a federal grant from the federal government, and the state and federal governments work closely together, we are providing training in schools for prevention. We're doing it in English. You know, if you write a paper in English, then it can be on the topic of domestic violence or an art project and things of that nature. You know, domestic violence is learned behavior. It's not like that you have a gene that you're going to beat your wife. So the good thing that we have found about it is that by intervention with victims of domestic violence and children, that we can prevent many acts in the future. Now, your specific question about how the case, and I'm not sure if it was in California, where someone was previously convicted of domestic violence was able to legally purchase a gun. In Mississippi, as part of this grant that we have a protective order registry in the Attorney General's office in Mississippi, and we also have a registry of the conviction orders. And both of those are interfaced with our National Crime Information Center, plus it's interfaced with our NICS system. That's the system that you do background checks for guns. That case should have been caught if that state had that system. And the good thing about the grant system we use is that this model will be taken to other states, and other states will use what Mississippi has learned in implementing that. So we hope that that will decrease, and we've seen a significant decrease in Mississippi from 5th worst incidence of domestic homicide down in the nation, down to number 22 or 23 about 5 years ago. On the issue, Mr. Kalin, you asked about pentobarbital. It is a drug that is approved by the Food and Drug Administration for purposes of surgery, anesthesia, and it is compounded by a licensed pharmacist in the United States. Quickly, back to Mr. Rodriguez-Recia's question about corporal punishment. For the 20 states that still allow corporal punishment, primarily all in the southern United States, most all of them have opt-out provisions where parents can write and request that their child not be subject to corporal punishment. And in addition to that, states have a protocol before that is a sort of a last resort punishment. You ask about suspension and zero tolerance of students. In Mississippi, the child has to be transferred over to an alternative school rather than being just suspended and left at home on the street. So they are sent to an alternative school where they continue their education process. The question about life without parole, Mr. Shinny, of juvenile offenders, the question is that, yes, in Mississippi, our Supreme Court has ruled that it is a retroactive application. So in our post-conviction relief process, those people who were convicted of crimes under 18, subject to a life without parole sentence, will in fact be resentenced. And let's see, last question is, Mr. Chairperson, on the issue of stand your ground laws in the United States. That terminology came from many southern states and in the West. The law has been in those states that you didn't have to turn and run from a conflict. You could actually stand your ground. So that's historical law in the United States. And these new statutes that have been passed have sort of gone beyond what was originally our understanding of self-defense. I was a district attorney for 8 years. I tried over 100 jury trials. Most of the time, juries do the right thing. And what happened is there was a national cookie-cutter model that some groups passed around to different states. They called them stand-your-ground laws or castle doctrine laws. And in Mississippi, we didn't need it. We had good self-defense laws. We prosecutors, were concerned that those statutes were going to make it more difficult to prosecute people who use excessive force. But thus far, what we have found is that, other than this Florida example that was mentioned earlier, at least in Mississippi, we have not seen a great increase in the number of what we think the jury changed their verdicts. Now, defendants seek more trials because they think that these statutes embolden them or give them more ability to get off, but that's the history. I think it does still comply with the covenants. Thank you, and I'll return it to my good friend and colleague, Roy Austin.
And just so you know, in the United States, we have special translators that translate northern to southern and southern to northern, so we all understand each other. So I have that embedded here.